Welcome to another episode of Garris Horn Insights. I'm Ray Sneichel. Today we have Ingrid Peterson, our partner, and we're going to talk about loan purchase agreements. And in this instance, we're not talking about what do you do in a situation when you have a buyback, but more importantly, how do you construct a loan purchase agreement that later there are no surprises or minimize your surprises when something might happen down the line. I think it's a great topic, and Ingrid, thank you for coming on to talk about this actually really important issue. And again, getting ahead of it so that we don't have issues later. I think it's a great idea. Thank you, Ingrid.
Oh yeah, thank you, Ray. Thank you so much for inviting me on the show today. I really appreciate the opportunity.
For sure. So now, we have some talking points that you've delivered. I think they're really tight and good. So I'm going to use that as my reference, if you don't mind, to introduce, kind of where you want to go on this discussion.
Yeah, perfect.
Very good. So, all right. Let me hit the first one. Is the agreement structured as an event of defaults framework, or is it based on a more traditional representations and warranties framework? What do you mean by that?
So when I first started practicing in this area 10 years ago, there were very few what I call events of default frameworks. An event of default framework is where there will be a provision in the agreement saying the following events constitute an event of default. And they can range from breach of representations and warranties to seller becoming bankrupt or insolvent, guarantor of the seller revoking the guarantee, to, and here crucially, receiving a repurchase demand from an investor. And that really makes a huge difference because in the past, the representations and warranties really concerned the underlying loan. So you'd have to actually breach one of those in the representations and warranties framework to be liable for repurchase or another remedy. But in the events of default framework, that simple act of receiving the repurchase demand triggers repurchase liability. So that's a huge shift, but it's a really small change in language. And that's a theme we'll see throughout this presentation is really small changes in language have really big impacts in terms of your real world liability.
Very good. Can you give me an example of maybe where you would see the subtlety in language as it's here versus there, just to give an example for the audience?
Yes, so the event of default would be something like the receipt of a purchase demand from an investor constitutes an event of default. Whereas typically you'd have to prove that the loan breached a representation and warranty. So those representations and warranties are things like, the appraisal is valid, employment on the loan application was correct, the income was correct, the assets of the borrower were correct. All those different credit-related criteria are correct and there's no fraud and misrepresentation. Whereas in the events of default framework, if you just told you're liable because we received a repurchase demand from Fannie Mae or Freddie Mac, there really is no way of defending against that if in fact the repurchase demand has been received.
Got it.
Whereas you can always defend, was this loan underwritten correctly or not? That's something you could attempt to defend, but mere receipt of a repurchase demand is not something you can defend, assuming the purchaser of the loan is telling the truth. And I've never come across an instance where they're not, in terms of the actual receipt of the repurchase demand.
Excellent, thank you. So let me get to your next point then. Evaluation of the nature of the risk posed by the representations and warranties. What's the focus there?
So here again, really small changes in language can have a very big difference. You could have a representation warranty that says all the information in the loan application is true. Or it could be, to the best of its knowledge, seller represents and warrants that all information in the loan application is true. Those are two very different things. The former relates to the actual content of the loan application and whether or not that's true or false. The latter to the seller's knowledge of the content of that loan application. So whether or not you know something, that's far more debatable than whether or not this person, the borrower, invented their employment. It's usually pretty easy to prove when a borrower has fabricated their employment. Whereas whether or not you knew the borrower had fabricated their employment, that's something it's far more likely you'd be able to come up with a competent defense to that allegation. Because then it comes down to, well, what was your investigation? What did you know about the borrower's employment? Did you know that, had you done a Google search for this company? Had you called the company? And if you've done all of that, and sometimes in these fraud schemes, they can be very sophisticated, where they will have a fake website. They will have a fake phone number where a confederate of the borrower in a fraudulent loan situation will answer the phone when they do the verification of employment, say, yes, Mr. Smith does work here as a accountant, or whatever his job is supposed to be, when this is in fact a fabricated company. So that you could say, yes, we went through our normal procedures as a lender. We did the verification of employment. We called the company. We searched them on Google. We found this company. It seemed to exist. So therefore, we did not know that this was a fake employer. So that's a huge difference in terms of your defensibility.
And I suppose it would be important to put a bright line as to when you would have had that knowledge, right? So whether it's
yes,
sale date, closing date, whatever, I guess it would be significant as well. Is that correct?
Yes, absolutely. And that's another important thing to check. Traditionally, representations and warranties are made as of a moment in time, and that's typically as of the closing date and the date of sale of the loan. But sometimes I've seen more sloppily drafted agreements where for some reason that timing piece is missing, and that can make it more open-ended as to when the time period and the period of time that you're representing and warranting as to. So, and then sometimes what happens is if you are missing the timing component, the seller guide will change later on. And then the question arises, well, are you representing and warranting that the seller guide in effect on the date you close the loan is what you're representing and warranting to, or is it one that came into effect, say, 3 months later and now has different requirements that you were not even aware of when you were underwriting the loan?
So kind of defining the quality of the awareness or knowledge, and then at a certain point in time that you possess that quality of knowledge. Does that make sense? It's kind of the key point here.
Right, yes. It's very important to try and make it to a specific point in time.
Next point. You mentioned here evaluating the scope of the remedies. So, and I think that's an important one because, again, if something happens and triggers, in addition to what we're talking about here, factually, did it happen, not happen, did we know, not know, it's also the pursuit of the remedy. Do I have to buy everything back? Do I can do something else? What are the options? And I think that's key. Can you explain that a little bit?
Yeah, so in these agreements, loan purchase agreements or correspondent agreements, they're sometimes called as well, the two main provisions for remedies are indemnification and repurchase. And for lenders, really the big one is the repurchase provision. And the main thing again here, and this also relates to what we were saying earlier, is that repurchase should not be a remedy simply because a third-party investor alleges there is a loan defect. And so again, it comes down to sometimes very small changes in the wording of the agreement. Sometimes one or even two words can make a difference in terms of the scope of your liability as a loan seller. The other thing I always look at is whether or not you have a repurchase remedy merely because an investor alleges there is a defect or because a defect actually exists. So lawyers, we love to dispute things and to have grounds to dispute things. Whether or not something actually exists, did the red car hit the blue car in a traffic collision? I can dispute that. But if it's, there was a police report about a traffic collision, that's something that's hard to dispute. Yes, this report was received, yes or no. So what we want to do is to get into the nitty-gritty of the traffic collision, not was a report received of an alleged traffic collision. So here the traffic collision in our loan situation would be, is there really a defect? And this is very important for underwriting defects, because on the fraud side, it can, if it's a clear case of fraud, it can be very hard to defend that. A lot of the allegations concern underwriting issues, such as, which guidelines were in place at the time. Did this borrower qualify to include the earnings from his previous job? Did he meet the requirements to include commission payments? And that's where you get into the nitty-gritty of the factual substance of what happened, and that's where you can find a basis to defend the repurchase demand.
Now, that's the case of, like I said, where the remedy is repurchase. I guess other remedies, there might be other remedies either side could work with or be in the agreement as well beside repurchase, correct?
Yes, of course. And then the other big one is indemnification. And again, we could probably do a whole webinar just on indemnification, but for the purposes of not getting too detailed and giving our listeners far more information than what they want to know about indemnification, there's just a couple of points I'd like to address. The first is whether or not you are required to receive notice of the claim, and at what point you are required to receive that notice. I mean, many of our clients have received and been in the horrible situation of years, sometimes even decades, or over a decade after the alleged loans were originated, receiving notice of there's now hundreds of thousands or millions of dollars in damages that an aggregator or third party is seeking from them. Meanwhile, for years, the underlying loans have been litigated, settlement agreements have been reached, and our clients have been kind of kept in the dark. They were unable to participate in the litigation concerning the underlying liability, and that's obviously a terrible situation to be in. So being notified of those types of situations, I think, can be extremely important. And then next, the other thing to really look at is the scope of the types of claims that you may be liable for. And something that's a fairly obscure point, but can also dramatically shift the liability landscape, is whether claims are limited to third-party claims only, or do they also include direct claims between the parties. And it's kind of a subtle point, but usually indemnification arises in the third-party context. In our loan purchase agreement, it'll usually be an aggregator, a trust, sometimes an agency that is suing the loan purchaser and is asking for that loan purchaser to pay damages, and then the damages are then passed down to the loan originator, or attempted to be passed down through this indemnification provision. But if your indemnification provision says something like all claims, losses, liabilities, lawsuits, damages, if it has that word all in it, that's going to include third-party and direct claims. But if you limit it to just third-party claims, then you'll leave out the direct claims. So that means that in a situation where there is no third party involved, they won't be able to invoke the indemnification provision against you. So that's a way of narrowing it down.
And okay, so you mentioned third party versus direct. Could you kind of define which one's third party and which one is direct?
So a third party would be somebody who's not a party to the loan purchase agreement. That would mean an agency or investor or aggregator. Direct means limiting it to just the parties to the agreement. That's the loan seller and loan purchaser.
So what I'm seeing here with indemnification and repurchase, just to make the bright line, repurchase is we see something here. We've talked about what kind of triggers, etc. But let's say they have a standing. We want to buy the thing back. We don't want anything to do with it anymore. Indemnification more is we own it, meaning we have sold it, and the other party to whom you sold it still has it. They write it out insofar as the legal issues, and what damages they have as a result, if any, is something they need to be made whole for as a result of probably that same defect. Does that make sense? So
Right.
buy it all back versus, okay, we're going to write it out, but any damages, any result here, you're going to have to make us whole. The key point you made to begin with, though, is make sure you're notified of that. So not it's been quiet for 3 years and suddenly, you're thrown this. So because there might be things that as a party, before indemnifying, you can help with. You can provide information or defenses for that party as well. So that's why you want notification, right? To be part of the process and make sure the agreement says that. Okay.
I just wanted to include one other little example about, again, how a very small change in language can have a very big effect on your potential liability as a loan seller is the nexus phrase. And kind of a cool word. Unfortunately, it doesn't have anything to do with the matrix, but it...
Okay.
We call it, and the technical term for it is the nexus phrase, and it's that little joining phrase between the long list of lawsuits, losses, damages, etc. Those things, claims, and then the conduct relating to those losses. So that joining phrase could be arising from, related to, or based upon. And those are very broad nexus phrases, and that will really expand the scope of your liability. Or you could really narrow it down and choose a narrow nexus phrase, such as caused by, solely resulting from, or to the extent they arise out of. And that really creates a causal relationship between the underlying issue and the damages flowing out of that issue. So, I have had whole lawsuits that have turned upon the fact that the other side could not prove causation. So that can be a very important defense as to whether or not you can ultimately be held liable for the underlying loan issues. Because as we all know, loans have a very long lifespan, and what happened at origination may or may not have anything to do with what happens to losses that arrive 10, 12, 13 years later.
Understood. And so, yes, I think the subtlety in language, I think that's good to know. As you said, the nexus, right? Next point here that you bring up, and I think it's a good one because it's interesting. It's called, you basically say, boilerplate provisions, issues to watch for. And sometimes contracts are nothing but boilerplates, we feel. And we just take it, we accept it, we skim through it, sometimes saying, sure, okay, whatever. But I think it's helpful here to explain what they are and the impact that they have. So I think you have a few you want to bring up here. But yeah, if you can tell us what you think about boilerplate and what we should look for.
So boilerplate is that chunk of provisions. It's maybe sometimes half a page or a page and a half, usually at the end of the contract, that a lot of people never pay any attention to. It can look like just a lot of legalese. But again, those little small provisions can have a really big impact on your potential liability. One thing I like to pay attention to is the force majeure provision. More and more agreements today have those in, and the force majeure provision is something that can limit or eliminate your liability if there is force majeure, or sometimes it's also called act of God, such as a natural disaster, pandemic, flood, act of war, terrorism, etc. And that's something, as we've seen with natural disasters such as the COVID pandemic, climate change related disasters, it's important that this be mutual. And where I see this coming up is usually after loans have been closed and sold, a major disaster strikes the area where the collateral is located, and then you have a huge number of borrowers going into early payment defaults or other types of default on their loans. So that, I think, is very important. And usually, if you ask them, the investor will agree to make it mutual. So then the other thing are these little tricky provisions where your the potential statute of limitations that applies to claims between you and the purchaser can be lengthened. Or even worse, the defense of the statute of limitations can be waived completely in some loan purchase agreements. And those to me are always absolute deal breakers because, again, like as mentioned earlier, these loans have such a long lifespan. You really don't want to lengthen that statute of limitations because 10 years, 12 years after your loan is originated, you may not even have a copy of that loan file anymore. The people that worked on that loan partly won't be with your company. The borrower may have died. I've seen cases where loans have been litigated and the borrowers themselves are no longer around to depose, to subpoena. That there's nothing you can do to get evidence to defend yourself. So that's really important to look at that. Then the other piece of boilerplate is to look at which version of the seller guide is going to be governing this transaction. A lot of agreements don't make this really clear, and again, you want to be able to lock in which specific version of the seller guide applies and at what date, because sometimes what happens in our industry is companies are inherently self-interested, and after COVID hit, for example, in the non-QM space, a lot of investors suddenly quickly added a provision saying that they would no longer be buying non-QM loans, and attempted to use that to rescind their purchase of many, many non-QM loans. And because this was across the whole industry, many of my clients were left now with a whole group of loans that they could not sell. So very important to lock that in. And the next thing I would really look at is the termination provision and what happens to loans that are in your pipeline in the event your agreement is terminated. And again, this applies more to non-QM or other types of less traditional products. It's very important to make sure that the purchaser is still required to honor those commitments after termination. And then finally, it's very important when making any changes to your loan purchase agreement to have a provision to the effect that it controls over the seller guide. And that's because the seller guide is going to be constantly updated, and the investor has the right to constantly update it. And of course, that right could also include adding provisions that completely undermine whatever changes you've been able to negotiate with the seller. So there is a way of crafting the loan purchase agreement and revising it so that whatever changes are made to the seller guide do not override what you have in your loan purchase agreement. So that way you can lock in those changes and there's no risk they can be overridden by future changes to the seller guide.
Thank you. I agree. Especially the boilerplate, we always think that's pre-agreed, so we all kind of know how that works, and so it's okay. And sometimes we should be more attentive to that because, specifically, as you mentioned here, it has actual material implications more than we think on the agreements and relationships that we have with these investors. Thank you for all of that. I think that was great presentation and really good information. There's a couple thoughts that I want people to think about as well. Ingrid, you tell me if you agree. But first of all, for example, any contract, I think for attorneys, for the most part, yes, we have certain provisions that we prefer for our clients versus the counterparty and so on and so forth. We do that. First threshold we're looking at is, do the parties know what they're signing? Do the parties know what the agreement says? So maybe you can live with certain provisions that, we would like to have it, but it wasn't a deal breaker. Ingrid, going to your point, maybe not everything here is a deal breaker. As long as you know that it says repurchase versus indemnification in this case, or that it was broadly stated as what the trigger or the indemnification, when it might come from more specifically. It's not that we have to sit here and get everything always in our favor, because you can't. Sometimes we have to negotiate. I think the key point takeaway here is know what's in your agreement. It might not be your favorite provision, the way you wanted it, but you didn't have a choice. But at least you know what that is and what you have, as opposed to we thought it was this and it was something else. Would you agree?
Yes, no, absolutely. That's really important, to at least know the level of risk that you're getting into.
Exactly. And I think the other point I want to make is, and I think you'll enjoy this one, is we often have clients, and their clients are going to be executives at a company, and they say, you know what, we just want a 2-page agreement. Like, okay, we might need to make it 17, but we want a 2-page agreement. It's not a big deal. Well, I often remind my clients, like, look, these agreements are not a big deal until they are, right? You don't need a lawyer, and you don't have to deal with the lawyers until you have to. So really, what we're trying to do by at least addressing these points and educating the client as to what either ambiguities, gaps there might be of what they want if they're not careful, or what the meanings of these terms are. Going to your point, like you said before, it's hard to assess the risk. So I tell them I'd love to do a 2-pager, but the ambiguities and gaps would be great. And sometimes it's against your interest. Are you sure you want it? Okay, fine. We need more pages. So I said, these agreements are never a big deal until they are. Did you get that experience also, Ingrid?
Yeah, I mean, sometimes clients don't like the fact that the agreements are as long and complicated as they are. And obviously there's always a trade-off between the complexity and, the time and effort it takes. But, I mean, typically most loan purchase agreements are usually 15 to 30 pages. The broker agreement will be usually 10 or 12 pages, so it's not that bad. It's not as bad as on the investor side, like the type of agreements the investors have with the actual purchases of the securities. So it could be worse.
Right. I like that. It could be worse. That's probably what we tell our clients more. Any closing thoughts, Ingrid, on elements, things you should look at on a loan purchase agreement?
I think it's just an important point to highlight is, like these small changes can have really big impacts, and it's important to also have these types of agreements reviewed by somebody familiar with the types of issues that come up within our industry, because our industry is really unique, and someone who's a contract attorney in a different industry won't necessarily anticipate the most likely problems that could arise.
Well, very good. Thank you for taking the time, sharing the information. Extremely helpful. Thank you, everyone, for listening and watching this podcast. We look forward to seeing you at the next episode of Garris Insights.
Thank you, everybody.